Good morning, honorable members and officials. I'm sure we should be able to start. Secretary, I was trying to look at my image and maybe I should actually just switch you off. Doesn't look good. And then we can actually then proceed with our meeting. Good morning. Welcome to everyone.
Good morning, Chair.
Morning.
Chair, I will call out the names of members on the platform, Chair. To our
yes.
Mr. Mbuyane,
Recording
Chair.
in progress.
Honorable Mbuyane.
Chairperson, good morning to colleagues. I'm present. Thank you.
Thank you. Welcome.
Chair, Ms. Mwatse, Chair.
Honorable Mwatse. Honorable Mwatse. Okay, let's proceed to the next one.
Chair, Mrs. Hermans, Chair.
Honorable Hermans.
Good morning, Chair, and good morning to everyone on the platform.
Welcome. Thank you.
Chair, Mr. Burns Namashi, Chair.
Honorable Burns Namashi.
Molo Slalo, molweni nonke malunga komiti.
Siyabulela enkosi kakhulu.
Chair, Ms. Mutahung, Chair.
Honorable Mutahung.
Good morning, Chair. Good morning, everyone. I'm present.
Morning.
Chair, Ms. Yaku, Chair.
Honorable Yaku.
Morning, Chair. Good morning, everyone. I'm present.
Good morning. Welcome.
Chair, that's all the members on the platform. We're correct. We can proceed with our meeting, Chair. Other members may still join us, Chair. I just have a copy from 2 members, Chair.
Okay, so obviously let's get to the apologies. Are there any apologies before we adopt the agenda, Secretariat?
Chair, we have Mr. McPherson, who is in inauguration party business, and we still have the medical apology for Mr. Thring, Chair.
Okay, definitely. Let's then look at the agenda of our program.
Chair, Mr. Cuthbert to join the platform as well, Chair.
Okay, welcome, Honorable Cuthbert. Good morning. And then can we pick up the next item on the agenda?
Chair, the agenda is we're receiving this morning the response from Adelaide Pandemerwe on the submissions with regard to the copyright and the performance protection amendment bills. But then after that is concluded, the committee will consider its 4th quarter report on the financial and non-financial performance of the TTIC, Chair.
Okay, so I think that was actually the issues that we think it's appropriate for us to proceed as the committee. Honorable members, if ever I can actually ask that you indicate if we can proceed in that order.
Mrs. Hermans raised her hand, Chair.
Honorable Hermans.
I propose that we adopt the agenda as tabled, Chair. Thank you.
There's a mover, honorable members.
Mr. Mbuyane, Chair.
Honorable Mbuyane.
Chairperson, thank you. I second the proposal for adoption of the agenda. Thank you.
Welcome, Honorable Mbuyane. Are there any objections? in the absence of any objection, I ask that we actually then proceed on the agenda as presented. So obviously we will actually then pick up on the first item on the agenda and be able to actually allow advocate to actually then take us through the process. May I invite the advocate?
Thank you, Chairperson.
Yes, welcome, advocate.
Thank you, Chairperson, and good morning to you and good morning to the members. Chair, I will be sharing my screen so that I have a PowerPoint going. Just want to see if it is there. It looks from my side that you can see it. Thank you, and I'm not going to take too long. I hope I'm not going to take too long, so I'll start immediately. Chair and honourable members, just to remind us what this process is about. This is not a new bill that is introduced. It is a different process, legislatively speaking. It is something that deals with the President referring two bills back to this committee because of constitutional concerns that the President raised. 3 of the concerns raised by the President have already been dealt with by this committee. It does not have to be considered again. These are the issue of tagging of the bills. That has in fact been done. It has been announced in the ATC of 18 June of this year. And the change to a 76 bill does not affect this committee. It will affect the NCOP process. The aspect of retrospectivity in respect of certain clauses and the aspect of impermissible delegations, these the committee has already agreed will be something that must be changed. It is done. We have dealt with those clauses, and both the retrospectivity and the delegations to the minister will be deleted from the bills. What remains are the constitutional concerns that the President raised in respect of the copyright exceptions, and specifically in respect of a procedural concern that there were amendments made and that these were not advertised again for public comment. Now, the committee has done that. We have advertised, and that is in fact where we are now in the process to consider the public submissions. The committee members have sat through public hearings. The committee has listened to the public. All the submissions have been made available to the members. The members are aware of what the public has said about the copyright exceptions, their constitutionality, and the public could in fact comment on any aspect of these exceptions because of the procedural concern. But we must consider that in respect of the exceptions and the public participation thereon, we are limited because of the Section 79 process to clauses 3, 19 and 20. But the committee also considered the concern of the President that the bills do not comply with international treaty implications. Now, in this regard, the advert called on the public to make comments on compliance, and this would be in respect of any clause in the bill. So any clause in the bill that indicated that there is, or on any clause where the public indicated there's a concern, the committee may in fact consider these. So as I've now said, this is part of the Section 79 process. And I'm just in my slides here highlighting the relevant rules to the committee, this aspect of confining ourselves to what the President has said. And like I've said now on the procedural concern of public participation, there's specific clauses, treaties, it's anything. From all the public submissions, there was only one clause that I will have to advise the committee. I could not find anything in respect of treaty compliance, and it was definitely not advertised. And that is for fair use exceptions. And that is clause 2, section 2A1B. The rest of the submissions all either dealt with treaty compliance or they dealt with clauses that were advertised, and the committee may consider those submissions. So what is the process now for the committee going forward? The committee has already reported how to deal with the procedural defects, and the committee has in fact dealt with the procedural defects. So what now must be done is now the committee must do what it said to the House it's going to do. We are going to consider the public submissions that have come in. Once the committee has considered those submissions, the committee can then decide on changes that have to be made. In respect of the substantive concerns on the retrospectivity, there will already be changes made and there will be amended bills. So B is probably where this committee is going. Of course, the committee might decide that the bill is so defective it cannot be corrected, and then C will be applicable. But from discussions, I suspect that we will be looking at B, where there will be a report with an amended bill. So that is where we are going from here. Now, if we look at the comments made by the public, first off, in respect of policy direction, there's two big schools of thought. One school of thought says we must continue with the current system, which is one of fair dealing. So there's a limit to what exceptions can be. If it's not allowed by the Act, it's not allowed. The other school says that we need a change in order to allow for more expressive, creative, all of these things in our economy. We need to give more rights to certain, to authors, to the creatives, to users, and that embraces a fair use approach. So in other words, there will be principles set out by the legislation, and then any action that a person does in respect of a copyrighted work will be tested against those specific factors. So that is when we look at fair use. Now, what happened in the Fifth Parliament is that the committee actually combined the two systems to an extent. In other words, the committee, or the current bills rather, gives a fair use approach, and that is in section 12A, where it sets out certain factors against which actions will be tested. But the bill goes further and also gives specific exceptions. So there's also lists to make things further clear and to provide some certainty. So it's a hybrid approach. Now, which policy direction to follow is, of course, something that the committee will decide on. How did this come about? Section 85 of the Constitution indicates that the President and the executive authority exercises executive authority with members of cabinet by developing and implementing national policy. That is what these bills reflect. They reflect a national policy proposed by the executive. And of course, now where the legislature comes in, where Parliament comes in, is that the executive has said, we need this in legislation. It's not something that we can implement without legislation. And that is where Parliament has to consider which policy. Well, first, if the policy is desirable, which it was found to be in the Fifth Parliament, and then secondly, if the legislation in fact complies with our Constitution, whether it gives effect to what the policy is that the executive is proposing. So how will the committee know what it is and why the department is bringing this policy to the committee? And we find this in the Memorandum of Objects. So if we look at the bill, it speaks to the purpose is to protect the economic interests of authors and creators of copyright works against infringement and to promote the progress of science, innovation, and useful creative activities. It will reward and incentivize authors of knowledge and art. And I just want to remind members that an author is not necessarily the copyright holder. There's a difference. The author is the person who creates the work. The copyright owner is the person who may exploit the work for profit, because there's rights attached to being a copyright holder. So the memo also speaks to it being consistent with the draft national policy. It refers to the Copyright Review Commission. And then it indicates that the alignment of these bills is for the purpose of incorporation of rights under international treaties to ensure effective governance, social protection, employment creation, and reduction of inequalities. Now, one of the public members of the public asked the question that fair dealing is part of the common law of South Africa. It is what is in our current Copyright Act, what is in our current Performance Protection Act. Why do we want to change? We cannot change now to a total different system of fair use. But that is not correct. The common law can be changed. It is part of our law, yes, but it can be changed. That is why we have legislation. Legislation, in fact, normally is to amend the common law. So Parliament has plenary power, and it allows Parliament to amend not only the common law, but also acts. And Parliament can change a whole system upside down if Parliament feels that the policy direction indicated in that bill is something that it wants to promote. Another comment then is on arbitrary deprivation. That was a big concern from the President's side in respect of the exceptions. And as part of this, we must also consider the whole system of fair use. And because the system of fair use itself speaks to certain aspects where a user may make use of a copyrighted work without, in fact, asking permission of the copyright owner. So the question, of course, when we look at arbitrary deprivation is, first off, is intellectual property property?
My apologies to interrupt, Chair. May we just ask Ms. Advocate Madumerwe to move her slides as she goes along, Chair? Sharing her slides, if it's possible.
Oh, Advocate, it's the moving of your slides. Okay.
Sorry, Chair, may I just ask if you can see my slides? Because on my screen, I am speaking to my slides as I'm talking. So I'm
on our side, your slides are not moving. We can see you.
No,
the slides were not moving. No, they're starting to move now. Yes.
Okay. I think what happened is that there's a problem with I've got two screens. So okay. I apologize. On my video, I'm going to now look away from you, but it's simply because I'm looking at another screen. So okay. Apologies for that, and thank you for bringing that to my attention. That is a bit irritating, actually. I apologize that you did not see the previous slide, but at least I spoke to them.
We are on the page of general comments, arbitrary deprivation.
Excellent. Thank you, Chair. I will now move on a different screen. So like I say, I'm looking away from you, but it's just because I'm looking at a different screen. So in respect of arbitrary deprivation, like I said, we need to look at whether intellectual property is in fact property. And when we look at various case law in this regard, there was a point in time where it wasn't sure what intellectual property is. Does it actually constitute property? In our first certification judgment, where the Constitutional Court looked at whether the draft Constitution is something that ascribes to the principles that were set out, the court did not make it a finding at that point in time. It wasn't expressly included. But after that, we've had a couple of judgments, the Lawfully judgment, a Moneyweb judgment, where the court actually stated that, yes, it is property and it is protected by Section 25(1). Now, when we look at Section 25(1), it allows deprivation of property. It doesn't mean that property is a right that cannot be touched. The right to property, in fact, isn't even a positive right. It is simply the right to not be arbitrarily deprived. So if we then look at what would be the principles that apply, well, first off, if we look at the Offered Enterprises case, the court said it's not necessary that there must be a physical taking of property. It could be direct interference. It could be indirect interference. It could be something that is not physical, as long as the impact is of sufficient magnitude. So yes, I agree that an exception to a copyright, the right of copyright holder would constitute deprivation, and it is something that we need to make sure that there is a proper balance. So if we then go to what would be allowed, well, Section 25 says you may only be deprived of property if it is a law of general application. Now, law of general application is something that in fact, it's easier to explain it by the opposite. It is a law that is not just applicable to a specific person. So a law of general application applies normally throughout the country. It could apply in a province, it could apply in a district, but it would apply to anyone affected by the principles in that. And both the bills are, in fact, laws of general application. So just out of interest, expropriation versus deprivation is simply that expropriation is where the state takes the property. So what we're talking about here is, in fact, deprivation. It's not expropriation. And when we look at whether deprivation is, in fact, arbitrary, we must look at a number of issues. So the First National Bank case, the court found that for Section 25, the test is a bit narrower than what Section 36, which is our general limitations clause in the Constitution, sets out. So when you look at things like reasonableness, justifiability, that is not applicable until we find that deprivation is arbitrary. So the only test is whether deprivation is arbitrary. If it is not, you don't have to look at Section 36. If it is arbitrary, then you need to see if the limitations that Section 36 allows are in fact complied with. Now, when will deprivation be arbitrary? It will be arbitrary when it's either not a law of general application, so it's one person, we are taking Charmaine's property. That would be arbitrary because it's not a law of general application. But if it is a law of general application, it will be arbitrary if there's not sufficient reason for the particular deprivation or the manner in which we do it is procedurally unfair. So when we look at something like sufficient reason, we need to look at relationships between what is the deprivation. So there's an exception, there is rights limited in respect of the copyright holder, and what is the purpose of the law? Purpose of the law is to balance certain rights. There's the right to equity, the right to education. These rights need to be balanced. So that's one of the purposes. Aligning with national treaties is another purpose. So secondly, what is the purpose for the deprivation and the person affected versus the nature of the property versus the extent of the deprivation? Now, the court also said that when it comes to land or corporeal property, the test will be a little bit more strict. So with intellectual property, the test is less strict. And we must then consider all of these factors, and you'll see that the purpose of the deprivation really plays a big role. So when we look at copyright exceptions, when we look at the whole fair use system, there's definitely a rational relationship between the means and the ends that we have here. And although we don't have to look at proportionality, there would probably, if a court would for some reason find that Section 36 needs to apply, it is quite likely that the bill would comply with that because it complies with the three-step test. So if we look at this, and like I've said before, this bill is trying to balance intellectual property with positive rights to education, dignity, equality, trade, freedom of expression. So just to reiterate, property is not a positive right. You have a right not to be deprived, whereas the rights to education, dignity, equality, trade is the right to. Every person has the right to education, and that is the way it is worded. So further, like I said, intellectual property is not land nor corporeal, so it will be less strict test. And also the exceptions do not deprive the owner of all the aspects of ownership. Both your fair use system and your fair dealing system complies with these principles. Both systems provide exceptions for the purpose of balancing rights, your rights on the copyright owner's side, not to be deprived arbitrarily, with other constitutional rights, the rights to education, equality, and so on. So the exceptions themselves actually align copyright with the digital era, and it promotes multilateral development. It also advances constitutional values, and it relates to matters that are of public interest and are for non-commercial purposes. So our office is of the view that there is definitely sufficient reason, and that the purpose is clear, and that the purpose is something that would pass constitutional muster. But there's also procedural fairness, because that's the other test in respect of arbitrarily depriving someone of their property. The exceptions are not open-ended. Section 12A, which is our fair use clause, provides a 4-factor test, and some exceptions even have additional limits. These limits are clear, and there's also international comparisons. Furthermore, the bill does not interfere with existing procedures. If someone feels that the 4 factors aren't complied with, or the other exception limits on the exceptions aren't complied with, that can be taken to court and it can be tested. However, it is always important to remember that legislation can always be improved. We can always put something more clearly. We can always make the extent of an exception more clear. We could add limits and so on. And that is something that the committee could consider when looking at what the public has said. The other concern was in respect of the right to choose trade, occupation, and profession. Now, the Constitutional Court, in the case of diamond producers, indicated that we must look at, if you look at a legislative provision, you must look at it objectively, and it would, if you want to see if it's negatively impacting the choice of trade, because that is what the Constitution says, it's the choice of trade that must be impacted. You must look at whether the legislation presents a legal barrier to entry. In other words, there might be a license that you need to obtain before you may practice a certain trade or an occupation, or if it imposes an effective limit on or an effective bar to that choice that would deter people from entering into that trade. And this last one was what people were concerned about, that there would be less profit to be made, and accordingly it would become more difficult for them to have viable businesses. However, we must keep in mind that these exceptions that are being brought into law, would be brought into law by these bills, are not new in the global arena. And globally, we've still got education in facilities, we've got academia, we've got people publishing in academia, we've got broadcasting, we've got music being made. All of these professions are still continuing in countries that are using fair use. Furthermore, the exceptions will bring forth and will be likely to encourage other forms of trade, other forms of occupations that will now come to the fore. So there is a bit of a payoff, yes, but it is to bring in balance, because at the moment the Act is more balanced towards, more in favor of your businesses that I think the minister explained is the one is looking at information and the other one is looking more at publishing and recording, and those kind of businesses would prefer a fair dealing approach because it benefits them more, of course. So if we look at regulation, although that is not really what the concern was, the question is whether there is a rational basis. And of course, we've gone through the purpose. We understand what the purpose is of the bills. There is a rational basis. It's not about whether you can do it in a more effective or less disruptive manner. That is not what the test would be here. It's simply about whether there's a rational basis. And our office is of the view that, in fact, there is. So in respect of international treaties, here I will not go into too much detail. The department briefed the committee on the treaties in detail. I thought maybe just to go and have a look for myself and confirm with this committee, because the committee is new to these bills. It was a whole process happening in the 5th Parliament. In respect of consultations to determine compliance with treaties, a technical panel was established in the 5th Parliament's committee, by the 5th Parliament's committee, and it included lecturer Advocate Joel Baloy on commercial law and intellectual law at UNISA, Mr. Andre Meiberg, who is an attorney solicitor and also a fellow of South African Institute of Intellectual Property Lawyers, Mr. Wiseman Gubo, intellectual property lawyer, business affairs manager from Capasso, and Ms. Michelle Woods, who was a contact from WIPO. And these advised the committee on technical matters, on policy matters, and of course the committee applied their mind in respect of that advice. On the issue of the three-step test, the department again spoke to this, and I won't go into too much detail on this. The three-step test indicates that exceptions must be confined to special cases, must not conflict with the normal exploitation of the copyright work, and it must not unreasonably prejudice the legitimate interest of the rights holder or the author. And when we look at the question whether South Africa, whether the bills actually comply with the three-step test, we must look at what has happened globally, because there isn't any country that is using fair use that has been challenged, so we don't have international case law to refer to. But when we look at the Australian Law Reform Commission, they have considered fair use, and their finding was that in fact fair use complies with all three cases, all three steps, including the first, as fairness, according to them, is in fact a special case. Then the Max Planck Institute also considered fair use, and their finding was also that you must look at all three steps. It does not require a narrow interpretation. Specific cases could be fair use as well. And if you look at fair use versus fair dealing, it is not any more or less foreseeable than the other. So there is no reason why the one would be more compliant than the other. And you need to look at the legitimate interests of third parties, and including interests from human rights and fundamental freedoms, which is, of course, where these bills are focusing, to try and shift the balance so that other constitutional rights, that the right to education, the right to equality, are also complied with. And if we look at whether, from what we have from a legal point of view, our court, the Constitutional Court in the case of Glenister versus President of the Republic, specifically referred to the Vienna Convention. And although South Africa is not a signatory to this, this is the convention that our courts use to interpret compliance. And one of the articles in the Vienna Convention specifically says any subsequent practice in the application of a treaty which establishes the agreements of the parties regarding its interpretation. In other words, once parties have signed a treaty, we must look at their actions after that signing, and that would give us a valid method of interpreting how the treaty should read. Now, if we look at countries like the Philippines, Israel, the Republic of Korea, Australia, and of course the United States, these are all countries that are signatories, and all of them use fair use. And that would then, if we apply the Vienna Convention's guidance on interpretation, indicate that fair use does indeed comply with the three-step test. Also, if we look at the economic and social benefits that a fair use exception would bring, our office is of the view that if our courts have to consider this, they will require very strong and persuasive arguments against fair use. And we do not think that those would exist. But again, specific exceptions, Section 12A can all be strengthened. It is always possible to make a bill more clear. Then I would like to speak to the committee on specific clauses in respect of which amendments have been are recommended either by myself or by the department. And I'll start with the copyright bill. The first relates to clause 1, the definitions. There are two proposals from the department in this regard. The one is to adapt the accessible format copy definition, and the second relates to technological protection measures. The department is saying that they would like to align this with the Marrakesh Treaty, and when considering the wording, it seems that the wording that the department wants to add relates to further restrictions in respect of what you can and can't do. So yes, we can amend this definition because it's part of the discussion on treaties. We won't have to advertise if we just make slight changing the words and to including to, that we don't need to advertise. But if we look at additional wording, it will depend on what that wording is. And I'm also of the view that we might not be able to add that to the definition. We might have to add that into section 19D itself. And if the wording is something new, then we might have to advertise this. In respect of the technological protection measure, again, we can amend this. It relates to the treaties. And I'm of the view that it is based on inputs from the public on existing text of the bill. It's not something that is a material amendment. We would not have to advertise this. Then the department proposed 3 new definitions. The one is of authorized entity. This is linked to the persons with disability. Broadcast and lawfully acquired. This relates to personal copies. And yes, we can amend these. They are part of public inputs on the exceptions. So they follow on that and definitely can be amended in terms of the Section 79 rules. However, because these are new definitions, they would be material amendments and will have to be advertised. And in addition, it extends the scope of the bill. So the committee would, if it decides to make these amendments to add the definitions, will have to ask House permission. Oh, I'm not getting my slide move now. The next one, right? Yeah. The next proposal from the department is to insert to amend a new section that is currently in the Act, but it will be a new clause to the bill. It is not something that the bill is currently considering to amend. So what they want to do is in respect of new exclusive rights of communication to the public, making available and distribution, they are saying that these rights have to be extended to computer programs. So this was an omission from the original bills. Yes, the committee can make this amendment. It relates to the treaties. But because it extends the scope of the bill, the committee will have to ask House permission, and it will, of course, have to be advertised. The next amendment is something that is a proposal from my side or a recommendation from my side. Public indicated that if we look at Section 12A, our general fair use clause, there is a list of exceptions. Some of these exceptions are in fact repeated in 12D, 12C, 12B, C or D. And so the argument was that you don't have to repeat them in 12A. And I looked at them and I could see some exceptions that do overlap. For instance, research, private study. This is in fact already in 12D relating to research and private study. Also 12B, something to relating about current events. I would suggest that this is retained. There's a proposal later on to remove 12B1E1. And that is where we will recommend that be removed. So current events be retained in 12A. Scholarship, this can be deleted. It is already covered in 12D. Illustration should be retained in 12A because where it is repeated, it relates specifically to education. So this in 12A is broader. The issue of libraries, archives, and museums are totally covered in 19C. And then, of course, if the committee agrees to these deletions, then there's a consequential amendment that will have to be made just to make sure that we don't lose the wording of 12A. If it is not captured in the other section, we will have to capture it there. And the one that I could find was in respect of using something at a different time or a different device. And definitely we can amend this. And I'm of the view that we don't have to advertise because it simply speaks to removing duplications and streamlining the bill. In respect of still Section 12A, there were also comments on being more explicit about the moral rights of the author. Now, the bills at the moment indicates that you should mention the name of the author as far as it is practicable. And the public were concerned that this might lead to a loophole. People might say, oh, hey, it wasn't practical for me. But what does that really mean? What is practical for me might not be practical for someone else. And they referred us to Section 12.4 of the current Act, which says that the source shall be mentioned as well as the name of the author if it appears on the work. Now, this is an easy amendment to be made. It has to be made to a couple of sections though, but it's very easy to be made. We don't have to advertise it, and it is part of the public's inputs on exceptions. It will strengthen the bill. It will make something clearer, and that is a recommendation to be made. Another aspect that the public mentioned is that it is not clear that the fair use regime applies to these specific exceptions. Now, remember, as I've explained, the committee in the Fifth Parliament had to decide fair use, fair dealing, and they decided on a hybrid model, something meeting in the end. So we have fair use with its factors, but we also have a list. And the intention, of course, was always that fair use must apply to all of these. But the public was saying that is not clear enough. So we can add something to 12A to indicate that all these exceptions are in fact subject to the fair use factors. In general, I don't think the wording needs to be advertised, but to err on the side of caution, and especially if the committee is already advertising something else, I would recommend that we do advertise that proposed amendment. Then moving on to section 12B, now we are looking at there's no specific exceptions. The one comment was that the bill uses the extent justified by purpose, and that this is not what, aligned to treaty language. Treaty language uses fair practice, and that is what we should rather be using. So I did a little bit of research of my own. I found an article that indicates, well, actually the two phrases mean exactly the same, but that also means that it is very easy to change extent justified by the purpose to fair practice. There will be no real change in the content of the bill. It's an easy amendment to make, and it will accommodate the inputs from the public. And I've indicated all the clauses where this amendment will have to be made. Then 12B1C, this relates to the reproduction of a work by a broadcaster. And the department was proposing that instead of the wording that's currently in the bill, as proposed by the public, we rather use the Canadian Copyright Act's wording on ephemeral provisions. We can amend this. It is part of compliance with treaties. It's also published for public comment, so we can definitely amend this. However, comparing the wording of the bill at the moment and the wording of the Canadian Act is very different. And I would recommend that if the committee agrees to this amendment, that it must be advertised. Then this is now what I referred to before, 12B1E1, relating to current events. And what the public indicated is that this is actually sufficiently covered in 12A. So we should keep it in 12A, but delete it in 12B. So that is the proposal, and we can definitely amend it. There's no need to advertise it. It is simply removing a duplication. Still on 12B, paragraph F in subsection 1, translations. The proposal was to promote the Bill of Rights and reflect the full range of purposes. In other words, we need to add language and culture. This is something that came from the public. We can amend it. It is part of those exceptions that were published, and we don't need to advertise it. It is not a material amendment, and it relates to the existing text of the bill. Then another proposal from the department in response to inputs from the public is that personal copies should only be allowed for works that were lawfully acquired. Now, to some extent, this actually speaks for itself. I think if a court would have interpreted it, would have been clear that you cannot make a copy of something that you've already, you're already standing behind the door. Your copy of that can't be justified. But what the department is proposing is both a definition of a phrase lawfully acquired, and as I've said when I discussed clause 1, that definition, the committee will have to ask House permission and it will have to be advertised. But the inclusion of acquire lawfully into 12B1I actually is not a problem. We don't have to advertise that. It is something that we can amend. Then section 12C. I've indicated 12C and 12D because there's one aspect that applies to both, but I'll only speak to 12C for now. There is a layout error in this clause, and I've tried to indicate it there. You can see that the phrase, as long as there's no independent economic significance to these acts, is applying to paragraph B only at the moment, because that is what it is part of. It should actually have been underneath paragraph B, because it applies to both A and B. It is something that we call a sandwich clause, and it's unfortunately something that happens often in the printing stage, where the shift in the enter is just removed and it jumps up to the previous line. Something that I would definitely recommend the committee amends. It's no need to advertise it. It's a technical amendment. The other proposals coming from the public on this specific clause is that this phrase shouldn't actually even be independent economic significance. It should be commercial. Commercial is defined, so it is something that can be done. And then the department also proposed that the three-step test be added to this. And that is where 12D, the same proposal is made in respect of 12D, that the three-step test be added. In respect of the three-step test, yes, it is something that the whole bill already complies with. It is already almost, the basis for the bill. But I would still recommend that we err on the side of caution. And if the committee agrees to include a three-step test into 12C and D, that the wording is advertised. Firstly, when we look at the specific wording of the three-step test, it must apply to all instances, for instance. That sentence will have to change. You'll have to adjust to fit into the bill. And already that means that you might have something new. There might be people who want to have it worded this way or that way. And I would really recommend that that be advertised if the committee agrees with that change. 12D I've already spoken to, so I'll just pass it by. Then section 19C and 19D. In respect of 19C, it's again a duplication proposal from the public. And the department also proposed this when they presented. So subsection 4 in section 19C ends with the words, but may not permit a user to make a copy or recording of the work for commercial purposes. And this is correct. We understand why that limitation is there. But when we look at subsection 1, it already provides that limitation. And then subsection 1 says you must apply to all of the subsections that follow. So in effect, this is a duplication, something that we can amend. No need to advertise it, as it is something that comes from the public. It's not a material aspect, it's removing a duplication. 19D3, now this is where the department proposed a new definition for authorized entity. And as I've said, for the definition, it's new, it will have to be advertised, house permission will have to be obtained. But to insert the word authorized entity into 19D, that itself need not be advertised. It is something that comes from the public in respect of existing text. It's to make something more clear. It's not a material amendment. However, I would recommend that we don't only look at 19D subsection 3, but also to 19D subsection 2, because the wording is more or less the same. And if you want to add authorized entity, you will have to add it into that subsection as well. Then clause 29, sections 28O and 28P. Now, these were not advertised, but the proposal is in fact in respect of a technical amendment, but the public also linked it to treaty compliance. So the committee can definitely look at this amendment. Strictly speaking, in a technical sense, this amendment is not necessary. The two sections, 28O and 28P, refer to the Electronic Communications and Transactions Act and specific sections in those acts. When the bills were deliberated on, we knew that the Cybercrimes Bill was going to actually delete those specific sections. But what we didn't know is whether that Cybercrimes Bill will in fact be passed in the form that it was at the time, and if it will be, of course, then assented to. And you can't draft legislation based on the wording of another bill. It is problematic. But in the meantime, since these bills have been passed, the Cybercrimes Bill has also been passed and it has been assented to. It's not yet operational. So the sections are still on the Electronic Communications and Transactions Act. It's still part of it. But once cybercrimes become operational, those sections will fall away. So at this point in time, it is an opportunity to remove those sections from the bill so that once Cybercrimes Act becomes operational, you don't have this, the Copyright Act referring to deleted sections. What would be the impact if we delete it now? Well, all acts must be read together with other acts. So in some sense, it was superfluous to add it, although it added clarity. It made you aware that you have to look at another act. but in practice, there will not be any difference if it is removed at this point in time. And of course, we can amend it, and because it's technical in nature, it needs not be advertised. Another technical amendment is something raised by the public, is that section 39, paragraph CH, in fact refers incorrectly to 28B when it should be 28P. So this is an amendment that is technical in nature, and it can be made by the committee. I then move to the Performance Protection Bill. And again, I'll start with clause 1, dealing with definitions. So first off, broadcasting here was brought up by the public that it shouldn't include transmissions by wire. And the department considered that and agreed that is something that could probably be removed to give it a better description. And it is something that the committee can amend. It's not something that needs to be advertised. And unlike copyright, where broadcast was not actually in the bill to start off with, and therefore house permission is needed, on performance protection, broadcasting is in the bill, so there's no extension of the scope of the bill, and the committee can amend it. Then the department proposed that the definition of producer, it refers to a person, and the department recommended that we add or the entity, so the person or the entity, which, to align it with a WPPT definition. From our side, our office would not recommend this amendment. What happens is that although the treaty might say person or entity, that is because the treaty is speaking to various countries, and various countries will be considering the wording of the treaty. But every country who considers the wording of the treaty must also consider their own legal and legislative principles. In South Africa, the word person automatically includes natural and legal person. So we do not have to say or entity, because entity is simply a legal person. The concern that we have is that if we add something to the word person in this definition, we are by implication amending the meaning of the word person right throughout the Act. So we will either have to define person in performance protection to say that it includes legal and natural persons, which is how it is interpreted anyway, or we will have to go through the Act and amend every place that we find person so that we can indicate natural or legal person. Because otherwise, if the rest of the places in the Act where person appears now,
recording stopped.
This definition, automatically person in all the other instances will revert to only being natural person. And that is not something that I would think is advisable. But it is an amendment, however, if the committee decides that we need to do it, it is an amendment that can be made. It doesn't have to be advertised. I would just recommend that there needs to be consequential amendments then. In respect of section 3A, the concern was that currently 3A reads, the contract must set out royalties or equitable remuneration, whichever applicable. And the public commented that this creates uncertainty because in respect of performances embodied in sound recordings, the system that you apply is only equitable remuneration. But for audiovisual works, it can be either. So you cannot just say whichever is applicable because it doesn't give that clarity. So the proposal is to make it clear which system applies to which type of performance and or fixation. And yes, we can amend it. There's no need to advertise it because it's simply making something clearer. Then a technical inclusion in section 8D. 8D reads, the minister must make regulations prescribing compulsory and standard contractual terms be included in agreements to be entered in terms of this Act. So the word into is not appearing there, and that was simply an oversight. And it is something that we may amend. We have a precedent in the expropriation bill that was referred back by the president. There was a correction in respect of a cross-reference that was incorrect without that being part of the president's reservation and without the bill being opened up for public participation. So there is a precedent. It is something that the committee can do, and it's no need to advertise this. Members, thank you very much. That is my presentation on the matter.
Thank you very much. I'm sure we should actually be able to go to members' comments and or questions for clarity. And obviously, I think we should actually then speak to process moving forward as well. Are there any comments, questions from members? Secretariat, if you can just check.
Okay, we have the hands of Mr. Cuthbert, Mrs. Hermans, Mr. Benjamin Marshall, Chair.
Okay, Honorable Cuthbert.
Thanks very much, Chair. Depending on who the participants are, I always think it's important to preface that it's only been in this term that I've been able to see this particular bill. I just have a couple of concerns.
Recording in progress.
It leads or stems from the concerns that I raised in our previous meeting where we discussed the copyright amendment bill. And if I look at the sources that are used by the advocate, and I respect the fact that a significant amount of work went into this to produce this presentation. However, if I look at some of the sources that are provided and some of the arguments that are used to justify, the criticism of the fair use regime, for example, they seem to be very similar to, proponents that came forward and provided public submissions, and too close for me not to notice. And I find that to be concerning in itself. Now, I have no, question about the advocate's integrity. However, I still can't help but think, in light of the previous discussion that we had at our earlier meeting, that this seems to be some sort of a stitch-up and there's some preordained outcome that's supposed to be achieved here. I would have expected that we would have been given, a far more objective view on how to handle these particular amendments, but these seem to get us to the executive's point of what they want to achieve. I also find that the sheer amount of amendments made to this bill, and it may be the case that it is a common occurrence, but to my mind, it seems as if there are a significant amount of amendments to this particular bill. And that just shows the flawed nature of the bill. And what we must also understand is that this is only confined to specific sections of the bill, yet there are so many amendments that are required, which just shows the fundamental flawed nature of this bill. And the fact that it is not suitable for the context within which it finds itself, and that it was a rush job that was done by the Fifth Parliament in order to try and, execute the executive's bidding. And I have a serious concern with that. I also don't think in terms of public participation that the concern I previously raised was adequately addressed. It was as if it was just battered off, and I want to believe that it was done with good intention, but I don't think that it was substantial enough. However, I do believe a more broad range of intellectuals and academics could have come in to train the committee itself or provide input to the process. And I don't think that that was necessarily considered. And I don't believe that it was actually the intention by whomever arranged said people to come and present to the committee. And I just feel as if a foregone conclusion has already been arrived at. And us as members of Parliament, and I would say this particularly as a member from only the 6th Parliament, have not been given an adequate opportunity to be able to participate in this bill and be provided all views. It seems as if we are being painted into a particular corner, and I find that to be highly problematic, and I find it to undermine the spirit of this committee.
Okay, can take Benson Amashi.
Thank you very much, Chairperson and members of the committee. I think the first thing, Chair, is just to appreciate the very comprehensive presentation by Advocate Father Merve, pointing out a very pertinent issues that as the committee we must consider, particularly as legislators, because finally the responsibility rests with us in terms of ensuring that the kind of legislative instruments that we pass as Parliament are an embodiment of those values which protect the creative inventions of our people, as well as promoting, the innovations that our people must be innovative and unleash that human potential as our constitution envisions, as well as create an opportunity to incentivize. These are very key, important aspects and principles that underpin the outcome of a legislation which is responsive and really in the interest of our people. So to the extent that Advocate van der Merwe has actually pointed out those issues, that has then created space for us as a committee, as well as Parliament in general, to really have a sense in terms of what needs to be done. Obviously, we will do all of this not being oblivious to the pushback by other interests, particularly the interests of big business, because it means now you are bringing a new regime that sets the original creators and inventors of the work at the center stage, and that for whatever that they produce, it must be protected after decades and centuries of exploitation. So to that extent, I think I would imagine that we as members of this committee and as Parliament in general, we are now seized with the opportunity to do what is right. And what is right is to pass legislations that protect our people, that promote innovation, and that incentivize originality. And I just want to ask a question from Advocate van der Merwe, especially with regards to the international treaties. You see, Advocate van der Merwe, I'm aware that it may not be binding, but it's a very important instrument. And that instrument is what is called the Declaration on the Rights of Indigenous People. Now, I want to check its relevance as well as the principle that is inherent in that declaration, which is the principle of free, prior, informed consent, which forms very critical tenet of that declaration as it relates to the rights of indigenous people, as well as the section 39, especially subsection 3 of the Constitution, to the extent that it puts customary law in the same pedestal as it would apply to a common law Roman Dutch law, so that when we deal with these legal interpretations, we don't just limit ourselves to common law and Roman Dutch law, but also we must also find space for customary law, because South Africa, as I always emphasize, is not only a metropolitan society. It is largely a cosmopolitan society. A significant number of our people are in rural areas, and most of creative arts, cultural work, in most cases, it embodies the value ethos of those people in the rural hinterland. So I would be happy if we can also look into that. So far, Chair, I think, as I said, we seem to orientate our jurisprudence. Of course, we don't just orientate it, but it allows space for triangulation, you know, and I'm sure all of us will agree that if we are to use triangulation as an instrument to emasculate the strength of this legislation, surely it will be a legislation that is not only able to respond to those international challenges, but it will also strengthen the originality of our people. Thank you very much, Chair.
Honorable Hammonds.
Thank you very much, Chair, for this opportunity. And can I join Honorable Burns Namashe in thanking the legal team for the very clearly laid out briefing document that has just been tabled to this PC. I think it is definitely pointing us in the direction where we now, as a PC, must consider that legal opinion. And that legal opinion, we know, took into account all the submissions from the public and stakeholders through that process that we had. I just wanted to check. Honorable Cuthbert, in the last meeting, raised an issue around the people, the academics who came to do our introductory training on this legislation, and the fact that they came to make submissions when they were given an opportunity to do so because they operate within that sector. So my question to Honorable Cuthbert is that he received an explanation from the PC Secretariat on why those particular academics were chosen to do the training of this PC. And he did not raise an objection to that explanation. And now he's reiterating it again. Who has been left out of this equation in terms of giving us a perspective on this amendments to these two bills? Because surely those experts or those stakeholders had an opportunity to also make a submission when the whole country was given an opportunity to do so. Because I think it is not right for us to, by implication, impugn the integrity of our legal team. Because if somebody has been specifically excluded, let us bring it to the fore and let us discuss it. But I think, Chairperson, the process going forward is that we will have several days of deliberations, and I look forward to us engaging on the recommendations from the legal team. Thank you very much for this opportunity, Chairperson.
Honorable Yako.
Thank you very much, Chairperson. I don't know. This bill is very, very convoluted. It's a very I don't know how to express it, but there's a lot that I think we are not entirely some areas that we're not fully understanding. And I'd like for us, perhaps as a committee, to be patient with each other. It would make things much easier for the outcome. I would just like to ask the advocate if Australia did adopt the fair use term, or they adopted the fair dealing term, because fair use was going to have a negative impact on its local content. And also, another question I have is, I know the previous parliament did have experts that were consulting, which is how they got to then the final end of the bill before it got returned. Have we utilized any of those previous experts in this sixth parliament, in this new consultation with the new committee? Thank you very much, Chair.
Okay, let's actually get Secretary. Are those the only comments we've got? Are there any further?
Just Mr. Mbuyani, Chair, and Mr. Cuthbert raised the Chair.
Okay, Honorable Mbuyani.
Chairperson, thanks for the opportunity. And also let me welcome the presentation by the advocate. It's very much informative. Chairperson, let me acknowledge that. And also, Chairperson, it is advisable not to rush to process into conclusion as to this bill was presented by who and so forth, who was given an opportunity to present and blah, blah, blah. Let us be sober in this bill and understand why we are here with this bill. Because some people are going beyond their mandate and scope in terms of their remitted bills. And this bill was created so that it responds to our poorest of the poor, and that are not even benefiting and are still not benefiting. Hence that we must be careful when we deal with this bill, because there are artists, writers, publishers who are supposed to be beneficiaries of this bill, and they are not taken care of. And we cannot allow a situation where we'll come here and discuss about academics that are competing, whether they will be correct and so forth. We're dealing with royalties and due benefits to the poor accordingly. One other issue, Chair, that I just wanted to check with the advocate, in terms of the clause 3, section 3A, the question of royalties and equitable remuneration. If there can be a clarity there, because that is what the bill is for, so that people are able to know what is due and how are going to benefit from the bill, Chairperson. And also maybe check the question of the treaties vis-a-vis the constitutionality of the wording of the treaties. Because our understanding is that even if you have not signed the treaty, constitutionally you are obliged to assist the people, the manner in which the sovereignty of the country is taking the toll, Chairperson. I think I'll pause there for now. Thanks for the opportunity.
Secretariat?
Mr. Cuthbert raised his hand again, Chair.
Honourable Cuthbert.
Thanks very much, Chairperson. If I may, through you, just respond to the comments made by Ms. Hermans. I think she's answered her own question in the first place by saying that we have several days of deliberations, and hence I've raised it. I didn't want to re-prosecute the matter at that particular meeting, and considering the fact that we are now deliberating, I believe I'm well within my rights to discuss this matter at this meeting, because I do believe that it's an unresolved issue. Also, maybe just to give a practical example. So say, for example, I was your political science lecturer and I come and teach you about governance theory and, political ideology and the like. And my natural inclination is to be liberal leaning. And I come and teach you that regardless of whether or not I try my best to be objective, my own personal beliefs will come through in the teachings that I give you. The same would go for if I was a Marxist or whatever the case may be. And this is what happens when you give certain individuals more than one bite at the cherry. Their views naturally become the predominant view that is held amongst members, and they're given more of an opportunity. So even if you don't intentionally mean it, it may still come across in that way. And just because of your own worldview, those kinds of interpretations will be passed on to the people that you're training. And I think that holds, and that argument holds for this specific instance, and why I keep on raising this particular concern. Now, just to give you a little bit more context, and this is a summation of some of the input we've received from stakeholders. But if you look at one of the professors, for example, he's very closely linked with the Washington College of Law, and they have actively, and this has been advertised and it's readily available to members of this committee, they've actively been involved on a worldwide fair use mission in order to raise funds and create emphasis behind the fair use regime. And there have been a number of contradictions that have been made by these individuals. In the last parliament, as far as I'm aware, they informed the committee that this bill would pass constitutional muster. Yet here we sit today, and the bill has been referred back to the portfolio committee because it does not comply with all of the necessary constitutional provisions. There's also been some admissions by said academics in the past that it does not in fact comply with the three-step test. And that is in itself rather concerning. And it shows to me that there is a link, and Mr. Burns and Ngamashe spoke about special interests, but these same individuals seem to be linked to special interests and big business. So it's rather ironic that his counterpoint to the argument that I made at the beginning of this meeting is one to accuse individuals of special interest and the like, when the very platform that was given to academics to teach and to train members of this committee are in part funded by international corporations. So I think that we must just be very specific and very true to the facts in this particular instance. Now, what could have been done was that the said academics could have been given an opportunity to provide the training, right? However, that base could have been extended to other academics who hold different views so that we got a more broad perspective on how to deal with this particular piece of legislation and intellectual property law in its entirety. But that was not done, and it was not opened up. Now, I do not know what the intention at the time of that decision was and how it was taken, but from all appearances, in my mind, it seems as if this was done to achieve a particular end result. Now, there were academics that came and gave public submissions, and they were given an opportunity to do so. I have no doubt about that. However, they were given one opportunity on the day of the public submissions, or the 2 days of the public submissions, whereas others were given 3 opportunities. Now, surely there's some sort of inequity there. Also, they clearly stated, and I remember the first law professor from the University of Stellenbosch saying that he was not given an opportunity despite having offered his services, similarly to the other academics that came through and trained this particular committee. Now, if there is a noted bias, let's not beat around the bush. Let's not try and obfuscate. Let's be honest about this, because it seems very clear to me, and as somebody who may not be as familiar with this bill as a member who may have served in the 5th Parliament, I can clearly see that there is some form of bias here, and I think that it is something that needs to be addressed. If there is a particular outcome that is wanted to be achieved here, which I believe there is, then let's rather own up to it and let's state it as such, rather than trying to create this facade of impartiality and objectivity, because I don't necessarily believe that it is true or that it is necessarily honest. And I believe that as public representatives, our first port of call is to be honest and to be clear with the public. And that's why I continue to raise this matter and will continue to do so, because I believe that it is in the public interest, and I believe that it has a material effect on the legislation that this portfolio committee is expected to consider and expected to refer to the House. So that is my input. I hope that it addresses Ms. Herman's concerns. I know that you yourself also raised an issue. Now, I asked very plain stated, straightforward questions, and it is a question that I would ask about any matter, is whether or not people were paid. It was confirmed that people were not in fact paid for it, and I accept that as an answer. However, I still struggle with the idea that people were given more than one opportunity, and they were allowed to give a presentation and training to members of Parliament free of any criticism or any alternative views. And I think it's always best that we get both sides of the story so we can make the most informed decision in the interests of the public and in the interests of securing property rights and economic freedom.
Chair, we have Mr. Burns from Namashi who raised his hand, Chair.
Okay, I would actually then invite Burns Namashi. And then let's actually then go back to way forward, because we are in the middle of a process, and it does look like we actually reflect backwards on what we've just gone through. But I think we have to actually agree on the way forward as well. Honorable Burns Namaji.
No, thank you very much. You know, it's not in my nature to enter into dialogues on matters of such important in fact, the issue we're talking about here is really important, and I think the idea is to create a broad framework which will provide guidance to us, so that as we do our work, we are mindful of those issues that have been raised by Advocate van der Merwe and any other scholar of note. However, Chair, it's important, Chair, to hone the issue around the resolve not to ever again pass a legislation that will deliberately and institutionally subjugate and exploit our people. And if anything that we argue for is not only about the legal correctness of the legislation, but it is also about justice. I think that must be very, 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 very clear to all of us. The legislation that ultimately should come out of Parliament, it must be beyond the narrow legal correctness approach. It must pass the test of justice. And justice in this case is about restoration of dignity of those who have been for years institutionally discriminated against, subjugated, and exploited. It doesn't matter how one may feel about it. It is an intentional resolve to do that. And it's a noble thing to do. Always be on the side of justice. Always be on the side of those who have been exploited, subjugated, and degraded. So the issue here is really about that. So I do appreciate the view expressed by Honorable Cuthbert. Yes, I respect the views in terms of different theoretical, of course, different perspectives or views by academics. Even academics, yes, I agree. They are the theoretical orientation of their schools of thought is based on to a certain degree different ideological orientations. It's a fact of life. However, in this case, as South Africans, and broadly as Africa being the continent with the history of being exploited and subjugated, we must always be determined in our resolve so that never again must this country see a legislation that has it doesn't matter how tiny it can be or how minute it can be, there must just be no element of exploitation of our people. I think, Chair, that is the thrust of our argument. Thank you very much.
Secretariat, this is work in progress. We should actually then be able to actually get comments from the advocate and then agree on the way forward, because I think that's where we're at, because we're moving step by step in terms of how we're picking up on resolution around these issues. Are there any further comments, Secretariat? Any further comments? If not,
no, Chair.
May I then request the advocate? And I think we should look at the way forward, because we're in the middle of an engagement, and we actually have to develop that program to take us forward and actually agree on what the way forward should be. Advocate?
Thank you, Chairperson. Chair, to quickly respond to questions and comments from members, in respect of Mr. Cuthbert's comments, that even from our presentation, it looked that there was a preordained decision. Chair, may I remind members that my advice is not on policy. I only advise this committee on legal matters. So this bill is proposing that the copyright regime in South Africa changes to fair use. That means that I will give the committee legal advice on fair use. My opinion, my presentation therefore did not focus on fair dealing because that is not the policy proposal. It is for this committee to confirm with the department what their objectives are. And I try to point that out by referring to the memorandum on objects. But that will be something for, as a discussion between this committee and the department to see what the objectives are and which regime will achieve that better. One thing that I do have to point out is that the concern with fair dealing is that it is not complying with the Constitution in respect of not recognizing certain rights, the rights to equality, education, and so on, all those rights that I mentioned in my presentation. So should there be a shift in the policy, in this committee decides to rather go for fair dealing, that is something that this committee will have to consider. How do we accommodate those other rights in the Constitution then? So just to explain from that perspective, that is why my presentation focused on fair use, because that is the policy proposal and that is where my legal advice should then be focused, which is in fact what I did. Then the question from Mr. Burns, that the legislation that you referred to was actually one of the first bills that I dealt with in Parliament. And I just quickly checked. The Intellectual Property Laws Amendment Bill was actually passed, or rather assented to, on the 9th of December 2013. There's an act that deals with Indigenous communities. And it was a lot of work. It was hard work. And there's a lot of processes proposed by the Intellectual Property Laws Amendment Act. It's Act 28 of 2013. The problem is that this act is not yet operational. And that is something that the committee will have to, by way of oversight, have to ask the department what the holdup is. Where is this? Why is this act not being made operational? What are the implementation problems? And if necessary, the act can be amended to address whatever those implementation problems are and so on. So it is a very good question. And it is something that is problematic because it's almost 10 years. It's 8 years now that this act is there, but not yet implemented. So that is something that this committee definitely can deal with, but it will have to be by way of oversight. The law is there. It is simply a matter of implementing it. Then the question from Ms. Yaku in respect of whether Australia, in fact, did go for fair use. At this point in time, Australia is very much in the same situation as us. They're still busy developing. However, their Law Reform Commission in 2014, so this goes back a long, long time, in 2014 considered whether fair use would comply with the three-step test, and their finding was that, in fact, it does. Then Australia, in their project towards a fair use approach, but at this point in time, the government is still consulting. It seems, however, that Australia will go towards a fair use principle, but of course, it's a bill process. As we are in this bill process, your